And welcome to Language Experts YouTube channel, where we talk about matters related to practicing interpreters and translators in Australia. This is part of an educational series we began recently, where we talk about what the duties of the interpreter are, how people view interpreters and translators, particularly from the point of view of users of interpreters in the legal areas. And today is part 5 of those educational series. Today's topic is on, is there an automatic statutory right to an interpreter? Is there an automatic statutory right to an interpreter? In a recent online publication, and that is N. Chulen provides a comprehensive summary of this issue. Chulen, and I'll make reference to the Chulen, who is the author of a publication. Bear with me for a moment, please. The publication is called Lost in Translation, an examination of court interpreting in Australia. Queensland Student Law Review, the University of Queensland, which we were able to access online. So Chulen is a legal practitioner whose publication, published by an Australian university, is considered an authority on those or these issues. The following information draws attention to these matters raised in her publication. Quotation: somewhat surprisingly, Australian common law does not provide an automatic right to an interpreter for any party to a dispute, including a witness or the accused. In South Australia, however, a statutory right to an interpreter exists for a witness who's not proficient in English in any court proceedings or when being questioned by police. Victorian and Commonwealth statutory provisions grant the right to an interpreter in more limited circumstances. Beyond these circumstances, and in all other Australian jurisdictions where the common law prevails, whether to use an interpreter is a matter within the discretion of the presiding judicial officer. In criminal proceedings, exercising such discretion entails consideration of the accused person's common law right to a fair trial, a fundamental aspect of the criminal justice system pioneered in Dietrich versus R10. Commenting on the content of a fair trial, the English case of Kunath versus the state continues a strong line of authority that it is an essential principle of the criminal law that a trial for an indictable offense should be conducted in the presence of the accused. Not simply that there should be corporeal presence, but that the accused, by reason of his presence, should be able to understand the proceedings. An accused who has not understood the conduct of proceedings against him cannot, in the absence of express consent, be said to have had a fair trial. Lema CL in R versus Tran elaborates, quote, the very legitimacy of the justice system in the eyes of those who are subject to it is dependent on they being able to comprehend and communicate in the language in which the proceedings are taking place. This consideration is paramount, irrespective of whether the non-English speaker is the accused themselves or a witness in the trial. The judicial officer must, in both cases, measure the likely influence of an interpreter on the trial's ultimate verdict. In civil proceedings, the disadvantage caused by the absence of an interpreter as a matter of natural justice appears subject to competing considerations. The possible prejudice to the interests of the other party deriving from delay and costs of interpreting services, the time at which the request for an interpreter is made, the necessity of an interpreter for resolution of the issues, ulterior motives for the request, and the reality that, for reasons explored below, evidence via an interpreter will not necessarily facilitate the ascertainment of truth. Importantly, however, as emphasized by Kirby J. in Gredage versus Grace Brothers, the judicial officer's discretion must not be colored by idiosyncratic opinions or personal views. The failure to provide adequate or proper interpreting services for a person when necessary for a fair trial may result in a miscarriage of justice, for which proceedings may be stayed. As a matter of practice, then, common law discretion usually favors the presence of an interpreter. However, certainty and uniformity call for a prima facie legislative right to an interpreter in all Australian states, displaced only on the grounds of discernible English language proficiency. Further, in accordance with the recommendations of the Australian Law Reform Commission, this right should apply in criminal and civil matters, but be dispensable in the letter if considerations of the above-mentioned character take priority. In assessing whether a person's level of English proficiency is sufficient to understand proceedings, either pursuant to statute or the common law, the often monolingual judicial officer faces an unenviable task. So as to avoid conferring an unfair advantage on those persons with some knowledge of English, courts have generally limited the use of interpreters to those persons with demonstrably inadequate proficiency. This approach has received considerable criticism, not least from Kirby P. in Adamopoulos versus Olympic Airways SA, who warned that elementary English is unsatisfactory for the purposes of communicating in court proceedings. Quote, the mere fact that a person can sufficiently speak the English language to perform mundane or serial tasks or even business obligations does not necessarily mean that he or she is able to cope with the added stresses imposed by appearing as a witness in a court of law. Judicial officers would thus benefit from objective criteria provided by a language authority such as NEAS Australia or English Australia to assist in the assessment of a person's level of English proficiency, language proficiency. Recent research on issues, problems, perceptions, and resources relating to the duties and function of an interpreter in the Australian legal system, carried out by Sandra Hale, has revealed a multitude of problematic issues present in the system at all levels. Professor Hale surveyed a range of legal professionals on these issues and has presented the outcomes in a recent publication. And we have included that publication in our references at the end of our handbook. This is Language Experts' own handbook from which I'm referring to. And we recommend the publication for further reading as it examines a host of practical issues affecting interpreters working in the legal system. Professor Hale's latest publication also provides evidence that many of the issues relating to the role and function of interpreters in the Australian legal system, which are also raised by Lester and Taylor in their publication of 1994, remain unresolved. You've been listening to Language Experts' educational series on who is the interpreter, the duties and the obligations of the interpreter in Australia. And today, in particular, we talked about, is there an automatic statutory right to an interpreter? Thank you for your attention. I'm looking forward to seeing you next time. If you have any questions, please don't forget to write to us, training@languageexperts.com.au, or visit our websites, www.interpreterrevalidationtraining.com. This has been Silvana Pavlovska for Language Experts. Thank you once again.